today this topic is reasonable restrictions. So it is necessary to maintain and preserve the freedom of speech and expression in a democracy that there are necessary restrictions imposed on this freedom for the maintenance of the social order, because no freedom can be absolute or completely unrestricted. And according to Article 19(2) of the Constitution of India, the state may make a law imposing reasonable restrictions on the exercise of right to freedom of speech and expression in the interest of public on the following grounds. So clause 2 of Article 19 of the Indian Constitution contains the grounds on which these restrictions on freedom of speech and expression can be imposed. These are first, the security of the or security of state. So security of state and of the government, this is very important for the power, and it must have the power to impose a restriction on the activity that can affect the security of state. And under Article 19, two reasonable restrictions can be imposed on freedom of speech and expression if it is for the interest of the security of state. However, the security is a very crucial term, and it refers only to serious and aggravated forms of public order like rebellion, waging war against the state, insurrection, and not ordinary breaches of public order and public safety like unlawful assembly, riot, and threat. In these cases, it will not come against the security of state. It will only come when the act is very aggravated and very serious, and thus speeches of or expressions on the part of an individual which incite or which encourages the commission of a violent crime like murder are matters which could undermine the security of a state. Now, friendly relations with foreign states. So, in the present global world, a country has to maintain a good and a friendly relationship with the other countries because of the globalization that is happening. And some things which has the potential to affect such relationship should be checked by the government. Keeping this thing in mind, this ground was added by the Constitution by the First Amendment Act 1951, which with the object that behind the provision is to prohibit unrestrained malicious propaganda against a foreign friendly state which might jeopardize the maintenance of good relations between the India and the state. So basically, if there is any kind of uh, hindrance that might occur with these kind of relations, then uh, this restriction can be imposed. Now, no similar provision is present in any other constitution of the world. So, in India, the Foreign Relations Act provides punishment for libel by Indian citizens against foreign dignitaries. So, interest of friendly relation with foreign states would not justify the suppression of fair criticism of foreign policy of the government. However, it is interesting to note that the member of the Commonwealth, including Pakistan, is not a foreign state for the purpose of this constitution. So Pakistan doesn't come under the foreign state, and the result is that the freedom of speech and expression cannot be restricted on the ground that the matter is adverse to Pakistan. Now, public order. So the next restriction prescribed by the constitution is for the maintenance of public order, and this ground was added by the constitution in the first amendment. So here public order is an expression of wide connotation, and it signifies the state of tranquility which prevails among the members of political society as a result of internal regulation enforced by the government which they have established. Now, if we move forward, public order is something that is more than just the ordinary maintenance of law and order. So, public order is synonymous with the public peace and safety and tranquility. Anything that will disturb this public tranquility or the public peace will disturb the public order. And thus, these communal disturbances and strikes promoted with the sole object of accusing unrest among workmen are an offense against public order. And public order does implies absence of violence and an ordinary state of affairs in which citizens can peacefully pursue their normal avocation of life. So public order also includes the public safety, thus creating internal disorder of rebellion would affect public order and public safety. But mere criticism of public government does not necessarily disturb public order. So the words that in interest of the public order, this includes not only such utterances that are directly indeed to lead disorder, but also those that have the tendency to lead to disorder. So, in interest to public order will also involve those kind of disorders that have the tendency to lead to a disorder. So, thus, a law punishing utterances made with the deliberate intention to hurt the religious feelings of any class of persons is valid because it imposes a restriction on the right of free speech in the interest of public order, since such speech or writing has the tendency to create public disorder, and even if in some case those activities may not actually lead to breach of peace. So just because there is a tendency of to create a public disorder, this will come under this clause. But there must be a reasonable and a proper nexus or a relationship between the restrictions and the achievements of public order. So now decency or morality. So the way to express something or to say something should be a decent one, and it should not affect the morality of the society adversely. Our constitution has taken care of this view and has inserted decency and morality as a ground. So these words are has a wide meaning, and section 292 to 294 of IPC provides the instances of restrictions on the freedom of speech and expression in the interests of decency or morality. So these sections prohibit the sale or distribution or exhibition of any kind of obscene words or in public places, and no fixed standard is laid down till now as to what is moral and what is indecent. And the standard of morality varies from time to time and from place to place. Now the contempt of court. So in a democratic country, judiciary is playing a very important role, and in such a situation, it becomes very essential to respect the institution and its order. And thus, this restriction of freedom of speech and expression can be imposed if it exceeds the reasonable and the fair limit and the amounts to contempt of court. So, according to section 2, contempt of court may be in civil contempt or in criminal contempt. But now, Indian contempt law was amended in 2006 to make truth as a defense. The seventh ground is defamation. So, one's freedom, be it of any type, must not affect the reputation or status of another person. So, a person is known by his reputation more than his wealth or anything else. So, the Constitution considered it as a ground to put restriction on the kind of freedom of speech. Basically, a statement which it is giving injury to a man's reputation will amount to defamation, and defamation consists in exposing a man to hatred, ridicule, or contempt. And the civil law relating to defamation is still uncodified in India and subject to certain exceptions. Now, incitement of an offense. So, this ground was adopted and added by the Constitution in the First Amendment 1951, and obviously, freedom of speech and expression cannot confer a right to incite people to commit offense. And the word offense is defined as an act or omission made punishable by law for the time being in force. Now, sovereignty and integrity of India. So, to maintain the sovereignty and integrity of the state, it is the prime duty of the government. And taking into this prime duty into account, freedom of speech and expression can be restricted so as not to permit anyone to challenge the sovereignty or to permit anyone to preach something which will result in the threat to the integrity of the state, of the country.